My name's Adrian Goldberg. This week they say justice delayed is justice denied, but we'll hear claims that an initiative aimed at speeding up the legal process is preventing victims getting the justice they deserve. On 5 Live Investigates tonight, have you ever been a victim of crime? If you have, you'll know that the wheels of the legal system can grind exceedingly slowly as the police, the Crown Prosecution Service and lawyers all assemble the information they need to bring about a prosecution. But tonight we'll hear disturbing claims that a new initiative aimed at giving the whole process a jump start is in fact having the opposite effect and leaving some of those on the sharp end of criminal behaviour feeling that they have been denied justice altogether. As always, we want your thoughts and comments on what you're hearing. You can text 85058, email goldberg@bbc.co.uk, or on Twitter, we're at BBC5Live. Rob Cave's been looking into this one for us, and Rob, this is all about an initiative called Stop Delaying Justice.
Yes, it was introduced in January in magistrates' courts in England and Wales, and it's known that the victims of crime are often unhappy with the length of time it can take for justice to be meted out. Many trials for relatively minor offences could go on for weeks or even months if witnesses didn't turn up or the defence lawyer asked for an adjournment, and that led to suspicions that some people accused of crime were just playing for time.
OK, so what was Stop Delaying Justice going to do to stop this lengthy, time-consuming process?
Well, the idea was that every trial heard in English and Welsh magistrates' courts, whether it's a domestic violence case or a speeding ticket, should be finished in 6 weeks from the case being listed for its first hearing. Now, that might still be many weeks after the offence was first committed, but under the new system, once the court process is underway, it shouldn't take more than 2 hearings to complete. Now, that's fine in theory, but it's led to accusations by defence lawyers who say that the trials are now being dealt with so quickly that there are miscarriages of justice.
Yeah, and it's not only lawyers who've been speaking out, is it? I know that one judge has been very forthright in his condemnation of the new system.
Yes, at a court in Oxford earlier this month, the judge, Recorder John Hardy, blamed Stop Delaying Justice for the decision by the Crown Prosecution Service to charge a 21-year-old babysitter, Daniel Hone, with actual bodily harm. And that was after he inflicted 28 injuries on a 19-month-old baby. Now, the case had been passed to the Crown Court and Hone was jailed for 3 years. But the judge said Hone should have been charged with the more serious offence of grievous bodily harm and sent down for a much longer period. He claimed that because of the new rules, the CPS had taken a robotic and mechanical approach to the case.
And we've got Keith Austin on the line as well. Now, Keith has a son, Carl, who was killed last year by a lorry driver who was charged with death by careless driving. But Keith had to fight to get the Crown Prosecution Service to take the case more seriously than they would have done. Good evening to you, Keith.
Oh, good evening, Adrian.
Just tell us exactly what happened.
Well, after the death of Carl, obviously the police did their investigations, and it took some time, but eventually, on the 14th of November, he was charged with causing death by careless driving. He appeared at the Magistrates Court on the 23rd of December, which was a hearing to decide whether he should be sentenced or tried, as it were, then at a magistrates or Crown Court, but that was adjourned mainly because the CPS had failed to provide the necessary documents to the defence team. Now, it was adjourned till the 17th of January, and the same thing happened again. The CPS had again failed to supply the necessary documents to the defence team.
And from your point of view, this should have been quite a straightforward case. I know that your son was killed on a very straight road. Your son had all his lights and his safety kit on and so on. And you were pushing for a more serious charge to be brought, given the evidence that was there.
Yes, that's what we were. I mean, we were told by the police that it was a serious charge. It was not. The least serious charge is momentary inattention, which could be dealt within a magistrates' court. But the police said that they thought it was more serious than that and should be dealt with in Crown Court. But on the 14th of February, when we sort of after the 2 adjournments went again for the hearing to decide whether it should be in a magistrates or a Crown Court, the first thing that was done was the CPS prosecutor stood up and said, as there were no aggravating factors, the case could be heard in a magistrates court. He more or less told the magistrates that's where it should be held, and that was what was decided. And they gave a date for when by then, of course, I forgot to mention, just before the 14th of February, the driver had actually pleaded guilty. So, he was just going to the Magistrates Court for sentencing. And that was put through to the 6th of March.
And did you get any sense of why the case wasn't treated more seriously than death by careless driving?
Well, no, I didn't really. I mean, I think the police had said that they couldn't really bring a charge of dangerous driving, which is the sort of the next stage up. But they did think it was in the sort of middle of the 3 bans for careless driving.
And did you feel that, in some senses, it was simply being rushed through to get a prosecution because the accused had pleaded guilty?
Well, I think so at that stage, and they certainly hadn't rushed beforehand because of the delays, and the adjournments. But on the 14th, yes, it did seem as if we were being rushed through somehow or other, and evidence which they obviously had was not produced because, I mean, when the CPS prosecutor stood up, he said that one sentence, sat down, and then the defence barrister stood up and spoke for at least half an hour without being challenged on issues that we knew should be challenged. But he never said anything.
Very interesting. Thank you for joining us. Very disturbing too. That's Keith Austin there. Rob, what did the Crown Prosecution Service say to you?
Well, in Carl's case, the CPS just simply said that the decision made at the Magistrates Court to send the case to Crown Court to be sentenced was made by the district judge after hearing the full facts of the case. Now, in the earlier case, in the court case involving the man who injured the baby, the CPS admitted they did get this one wrong, and have written to the judge to explain the mistake. But they said stop delaying justice was not the reason for that wrong decision.
So, essentially, in the 2 cases that we've heard about so far tonight, they're saying that this attempt to speed up the legal process, stop delaying justice, isn't the reason for the difficulties that we've heard about, but the legal profession is convinced that there is a wider problem.
Yes, I've spoken to lawyers who say they've represented clients who've been asked to plead guilty by the police and the Crown Prosecution Service before they've had chance to see the evidence against them. They'll be told the evidence exists, but they haven't seen it themselves. Now, the problem with stop delaying justice isn't necessarily the idea that things need speeding up, which is what the lawyers say. Mm-hmm. It's that the new timetable isn't giving the prosecutors time to disclose the evidence to those who stand accused.
Yeah, and that's a crucial difference. A little earlier, we spoke to Caroline Wilbraham, who's a solicitor with a law firm in Manchester. I asked her if she had seen genuine miscarriages of justice because of this problem with getting evidence in time.
I have a case of a gentleman who is in custody at the moment in respect of matters of essentially attempted theft at a cash point and possession of an offensive weapon, in that it's alleged that he had a knife on him. First appearance, don't get the CCTV. He's remanded into custody on the basis of the Crown's case that essentially it sounds like a serious offence. He's got a knife, attempted theft at a cash point. I got the CCTV the day before the committal hearing to the Crown Court. It does not show him holding a knife. It does not show the incident. But because we didn't have that CCTV, on the 3 bail applications that we made, despite requesting it on every single occasion, I think now, viewing the CCTV and seeing that there is no knife on the CCTV, seeing that clearly we've got a better chance of getting bail now, and that has basically affected the defendant's case on the basis that the case has not been ready. I think in some cases, because of the pressure to put clients to plea at the first available opportunity without the full file, sometimes defendants are pressured into pleading guilty to things that perhaps there isn't the full file, there isn't the full evidence, and perhaps the full evidence would never have been gained, and perhaps had the defendant actually waited to see if a full file could be prepared and not entered his plea, it may well be that they don't have the full evidence. They can't prove the case beyond reasonable doubt against him, and that perhaps he could have been acquitted at trial.
That was Caroline Wilbraham from Tucker's in Manchester, alleging that because of this new attempt to speed up justice, there could be, ironically, miscarriages of justice. As always, we want your reaction to what you're hearing. You can text 85058, email goldberg@bbc.co.uk, or on Twitter, we're at BBC5Live. Anna C. Young in Swiss Cottage says, Adrian, courts are inherently disorganised. It is nothing new. Still to come, if there's such a rush to get magistrates' courts hearings over and done with so quickly, why are victims of crime and suspected criminals finding their cases delayed by double and sometimes treble booking? On 5 Live Investigates tonight, we're hearing claims that a government initiative aimed at speeding up the legal process is denying victims justice instead. We've also heard from lawyers who say that the new rules, which apply to magistrates' courts in England and Wales, mean that suspects are more likely to suffer miscarriages of justice. We've been getting your comments on this. Rob Cave alongside me. What have you got, Rob?
Yeah, well, Mark from Luton is making a point that's been made by a number of other listeners. He says, if you're accused of a crime, then one of two things apply. you did it or you didn't do it. Therefore, you plead guilty if you did it, or plead not guilty if you didn't do it. It doesn't matter what evidence you think they have or haven't got against you. It doesn't change the truth. Just tell the truth.
Yeah, well, Mark in Luton's got a point, hasn't he? I mean, an accused person knows whether they've done the crime or whether they haven't. So why do they need to see the evidence before they plead guilty or not guilty? Aren't they just trying it on and wasting the court's time?
Well, you might think so, but life often isn't as clear-cut as that. There are all sorts of grey areas. If, for example, you've been accused of a motor offence or something that happened in a melee outside a pub, perhaps you sincerely think you are innocent and need to see the evidence against you before you decide. But you'll be in a bit of a quandary, because if you plead not guilty and are subsequently found guilty, you get a harsher sentence. And you might be a bit miffed about that if you hadn't seen all the evidence first.
Keep those comments coming. This is from Kevin on the text. He says, until something is done to the Crown Prosecution Service, which he describes as the Criminal Protection Service, there is no justice in this country. So is Stop Delaying Justice a fast track to injustice? Or do suspects and lawyers abuse the system by stringing out cases for as long as possible? You can drop us a text to 85058, email goldberg@bbc.co.uk, or on Twitter, we're at BBC5Live. Let's speak to Kieran Fielding, who represents people in the courts on Merseyside. Kieran, good evening to you.
Good evening, Adrian.
Now, I understand you've had a case where you had to investigate a crime yourself. Just explain that.
Well, we investigated our client's defence because the prosecution and the police hadn't done their job. There was a number of items of evidence which clearly pointed to other people, and the prosecution weren't prepared to listen to the representations being made that they shouldn't proceed with the trial.
And this was a case involving a young man who was accused of having stolen a car, but who had, I think, a cast-iron alibi, claiming that he was at college at the time, and he had people who backed up that alibi.
Well, not only did he claim he was at college, he was at college. His tutors said he was at college. When they arrested him, he had his college work with him, and the first thing that he said to the police when they arrested him was, "I've come straight from college." It's unfortunate that wasn't investigated by the police, and as a consequence of that, we had to go out, interview those witnesses, do site inspections, prove that things couldn't be seen from where police officers had said they could be seen. And then finally, on the day of trial, we found a prosecutor who was brave enough to kick against the system and not proceed with the case.
It's very troubling, though, isn't it, to hear of a young man being accused of a crime who had an alibi which could have been checked out pretty routinely, pretty simply, but it was down to you, as his defence solicitor, to establish his innocence.
Well, it is, because I noticed a comment from Mark in Luton before about you know if you've done it. Well, you also know if you haven't done it, but the prosecution and the police have a duty to prove the case. There is a presumption in this country that a man is innocent until proven guilty, or a woman is innocent until proven guilty. The trouble with Stop Delaying Justice is that the view that Mark has expressed about if you've done it, you should plead, is commonly being expressed by lay magistrates, district judges and Crown Court judges.
So we're flipping out that traditional assumption of innocence until proven guilty. We're now assuming, in your view, guilty until proved innocent.
It's not a tradition. It's a fundamental basis of the criminal justice system in this country.
And do you believe that Stop Delaying Justice is making the kinds of problems you alluded to in that one individual case? Is that now becoming commonplace in the Magistrates Court?
I can't say if it's commonplace or not, but I know that over the last 12 months or so, we are having to investigate more and more cases because the prosecution service, I don't want to be rude about them, but I don't think I can stop myself, are so bureaucratically constipated and badly managed that they can't actually do their job properly. There's a system where a lawyer in the police station or in the CPS office now gives advice about charge, and that cannot be changed, no matter what happens, without the authority of a senior person in the CPS. That charge will not be changed or amended or dropped, because the view is that the pre-charge advice is always right.
Could this lead to miscarriages of justice?
Yes, and people will think, here's a defence lawyer sticking up for rogues and villains, but it leads to miscarriages of justice for everybody. You've heard from Keith Austin before. I can't comment on that case, but there was potential there for miscarriage of justice. We regularly see defendants walking away not being charged when they should be. We regularly see undercharging, people being charged with offences because it keeps them out of the Crown Court, or because they'll plead more quickly to the lesser charge. There are people, obviously, who are convicted when they should not be. So yes, there's great potential for miscarriages of justice.
Kieran Fielding, that's very troubling evidence. Really appreciate your time tonight. Thank you. Let's speak to Stephen Nunn, who's a criminal defence lawyer in Exeter. Good evening to you, Stephen.
Good evening.
So, like the cases above, I mean, have you seen the Crown Prosecution Service bringing, in some cases, lesser charges or dropping cases because they've been in a rush to get these cases done in 6 weeks' time?
I think the time limit is now a major factor. They are discontinuing and dropping many cases because they can't cope with the workload they've got. You add an artificial, silly time limit, it's going to make it worse.
So, do you think there are people who are guilty who are walking free?
I think the answer to that's got to be yes. If you put a time limit, which means if you can't extend it, you have to drop a case, an innocent or guilty person will walk free. But
how does that work? Just explain that.
Well, the prosecution have to be ready by a certain date under stop. If they're not, and the work that needs to be done can't be done, they're going to ask to vacate the trial. And if the magistrates act even-handedly, the prosecution are going to get the case thrown out. That means a potentially guilty person will be released without ever having to stand a trial.
So there are guilty people who are walking free. Are there innocent people who are being wrongly convicted?
I'm certain that there has to be an equal number at the very least. As one of the people said this evening, the cornerstone of our system is the prosecution have got to prove a case, not for us to guess what their case may be. And to be fair to the prosecution, on the first date of hearing, they may have as little information that we're given on the first date of hearing. So in many respects, it's like a game of blind man's buff at the first date. Everyone was trying to work out what the case may be, as opposed to what we used to do and find out what the case actually was before setting it down for trial.
Do you accept, though, that Stop Delaying Justice is motivated by a very good and a positive idea, which is simply to speed up process, which can be, to speed up the justice system, which can be an incredibly long-winded and time-consuming process?
I don't accept it as it happens. I think this is yet another attempt to simply cheapen the system, spend less money, get fewer people involved, and not spend money on the prosecution, which dramatically needs proper funding.
So you think it's all about the cash?
I think a large amount of it is. A large amount is thinking foolishly, as the recorder said in the case you reported earlier, that justice delayed may well be justice denied, but justice on the cheap is equally as bad a thing.
Stephen Nunn, thank you very much indeed for joining us. And Rob, what does the Crown Prosecution Service have to say about this? You know, this charge that they're not keeping up with the demands of the new system, that they're struggling to get the evidence to court on time?
Well, the CPS said it fully supported the Stop Delaying Justice initiative and said it fitted in with its objective of helping to provide swift and effective justice while maintaining the quality of the prosecutions it undertakes. Now, as proof as how effective Stop Delaying Justice could be, the CPS said it had recently managed to successfully prosecute someone on the same day that the man had been arrested, even though he pleaded not guilty. But it also said that it was committed to providing the relevant information to defence in good time for a trial.
There is an irony in all this, isn't there, Rob, which is that despite the attempt to speed up justice, delays, in fact, are still regularly occurring in the Magistrates Court.
Yes, nearly 1 in 5 trials don't happen on the scheduled date, and that's a figure that's remained more or less constant for the past 5 years. So you can see the need to speed things up. But what's intriguing is the reason why they are delayed. Used to be because witnesses hadn't turned up, or the defence asking for an adjournment, or paperwork going missing. But now there's another reason which has become more of an issue recently, according to the lawyers we've spoken to, and that's double booking or even treble booking of trials.
OK, well, let's bring back Stephen Nunn, our criminal defence lawyer in Exeter. Stephen, do you know about this double and treble booking of trials? And if so, how does it happen?
Oh, yes, we certainly know about that down here. Trials are routinely double and treble booked. So when you go to court on the day, you may find that there's 2 or 3 other cases fully ready to go, all the witnesses there, defendants there, yet the court then have to decide which of the 3 cases goes ahead. One is the lucky one, the other 2, with all the witnesses and all the potential victims, are all sent away, and told, never mind, sorry about that, please come back another day.
Interesting. Let's speak to Richard Monkhouse from the Magistrates Association. Good evening to you, Richard.
Good evening.
Firstly, can you explain that? Why are some courts being double and treble booked and causing yet more delays to people who are awaiting justice?
Double listing has been going on for some time, for ages, ever since I've been a magistrate. One of the reasons is that every magistrate in the country could give very many examples of appearing in court for a trial to start at 10 o'clock, only to be asked for time for discussions which we are told could assist the case. This would be fine if this was done well before the whole cast of witnesses and victims turned up for a trial, but invariably it isn't.
So whose fault is that?
Well, the two parties should be getting together. If there are discussions to take place, these should have happened well before the trial date. Unfortunately, they don't.
But it's another example, isn't it, of how even since the introduction of Stop Delaying Justice, people aren't necessarily getting speedier justice, and in some of the examples that we've heard, they're not getting justice at all.
Well, I think that's very rare. I mean, there are two strands. Well, no, first of all, this is not a government initiative. It's a judiciary-led initiative. This is something that's been borne out by the frustration, particularly in magistrates' courts, of delays because parties aren't ready to proceed. So strand one of Stop Delaying Justice is basically when you appear at first hearing, you should be ready to give a plea. The prosecution should be ready with their case. They should have already given the evidence that they are relying on to the defence, and the defence should be in a position to say that their client is guilty or not guilty.
Well, with respect, we know that should happen, and the trouble is that, as we're hearing from a number of sources, that the evidence isn't being given to the defence in time, so that the 6-week time limit then becomes a farce and is likely to lead to miscarriages of justice.
Well, it depends what evidence you're talking about. The mention has been made of CCTV. If the prosecution aren't relying on CCTV evidence, then there is no necessity for that to be given to the defence before a plea is made. That may well be necessary in unused material to be given to the defence, and it would be given to the defence in order for them to prepare a trial. But it doesn't actually change the situation of the defendant. As Mark from Luton rightly said, a defendant knows if they've committed a crime or not, in most circumstances.
But they don't always, do they? If it is a motoring offence, you may want to see the evidence before you plead guilty. Well, if there is a fracas outside a pub, you may believe you are innocent, but you might need to see photographic or video evidence before you decide on your plea.
And if that is absolutely necessary, then that should have been done. And if the defence want to say to a court, this evidence, which the prosecution are relying on, has not been given to us, and can argue their case, then a bench will adjourn. But those adjournments should be rare. We're trying to change culture here. We're trying to say, don't arrive in court expecting that if you ask for an adjournment, you will get an adjournment, because those adjournment requests are going to be challenged. They're going to be questioned. And that's all really we're talking about. We want to change this expectation of delay. I can remember many cases where you've got to a trial date and it's the 8th or 9th or 10th hearing. That simply should not happen. That's delaying justice for the victim, and everything should have happened at a much earlier stage. So prosecution should be ready with the right charge, and defence should be ready with their plea of guilty or not guilty.
OK, Richard Monkhouse from the Magistrates Association, thank you. Don't forget, we're after your comments as well. Is justice being speeded up to the point where victims and suspects are being denied a fair trial? Or is it about time that lawyers and the police were forced to meet a timetable? You can text 85058, email goldberg@bbc.co.uk, or on Twitter, we're at BBC5Live. We'll be hearing what you've got to say shortly. Plus, the tobacco smugglers going undetected and costing the Chancellor billions. Plus, after we warned weeks ago that understaffing at Heathrow Airport in the run-up to the Olympics, we'll be finding out what, if anything, has happened since. On Fine Live Investigates tonight, we've been hearing claims that a new scheme aimed at speeding up the legal process in the magistrates' courts in England and Wales is in some cases allowing suspects to get away with crime, either because they're charged with lesser offences or are let off altogether. We've also heard claims by lawyers that suspects are being denied the chance to see the evidence against them in time, opening up the risk of people being jailed for something they didn't do. Is the initiative called Stop Delaying Justice simply delivering rough justice? You've been contacting us. Rob Caves alongside me sifting the emails. I got a couple of texts here, though, Rob, that absolutely split up the polar opposites of this debate. Noam in London says the reason people are entitled to see the evidence against them is because it's the prosecution who must prove their case, i.e. innocent until proven guilty. It is shocking for your programme to miss this basic point, says Noam. Another texter says, though, do you not think that if somebody admits to the crime, then the chances that they are guilty? Stop being so politically correct. We want justice and villains locked up. About time the media got the message. Give us a radio show that tells us about successful convictions and the villains locked up. There we go.
Yeah.
What else have you got there, Rob?
Yeah, I've got Darren Halstead, who's a defence solicitor in Preston, and he says in Lancaster and Preston, a generous view would be that in 90% of Magistrates Court trials, the CPS badly breaches limits by serving often vital documentation just before or on the day of trial. The courts often refuse adjournments for the defence to consider these documents and allow minutes for the defence to read them. The CPS has shed so many experienced, qualified staff, and courts have so few legal advisors due to cuts that the system has no hope of properly administering justice.
Yeah, we've got another one from Dave, who says he's a serving police officer. He says this worry by defence solicitors about seeing the evidence is a delay tactic so they can fish for prosecution disclosure. So basically he's saying that they want the information early from the prosecution so they can try and pick holes in it and, by implication, get guilty people off the hook.
Yes, and this one comes from a listener who prefers to be anonymous, and this is about this idea of double and treble booking. She says, my stepdaughter was due to give evidence at Swindon Magistrates Court recently after her boyfriend was assaulted. She had to take a day off from university, travel down from Lincoln. We travelled from Birmingham to support her, only for the case to be adjourned. The court had listed 5 trials to be heard in one courtroom. Our case was adjourned until July. Another couple in the witness room had attended for the second time for a trial. Their case was also adjourned. So as long as the court can say they've listed a trial within 6 weeks, fine. And they do not say whether they are actually heard or not.
Yeah, one more from Bonge in Bath, who says miscarriages of justice should not happen. All evidence should be shown, however long it takes. Thank you. Keep the emails and the texts and the tweets coming in. You can email goldberg@bbc.co.uk, text 85058, or you can comment through our Twitter account at BBC5 Live.
Across the UK.
This is BBC Radio 5 Live.
5 Live investigates.
Now, who's a smoker? If you are, you won't need me to tell you that in the most recent budget, the Chancellor hiked the price of an average packet by 37p. With 20 smokes now costing around £7.46, it's small wonder that cigarette smuggling is rife, accounting for more than 1 in 10 packets sold. And new figures seen by 5 Live Investigates show that conviction rates are falling for the illegal tobacco smugglers. Rob Cave's been investigating this one, and Rob, this is a huge business, isn't it?
Yes, the illegal tobacco trade is reckoned to be worth about £2.2 billion a year in lost revenue to the government. Just think how many hospitals could be built with that. And smugglers have become much more sophisticated in recent years, moving from a man with a van to organised crime gangs smuggling in cigarettes and tobacco by the container load. And to give you a sense of the money that can be made, each 40-foot container holds cigarettes with a street value of about £1 million.
That's pretty impressive, isn't it? But I thought the government claimed it was winning the war against these illegal importers.
It has been winning, because the government estimates 11% of cigarettes that are smoked in the UK are bootleg.
So that is more than 1 in 10.
Yeah, and about half the hand-rolling tobacco.
Yeah.
Sounds bad, but it's not as bad as it was 10 years ago, when around 20% of cigarettes have been smuggled into the UK.
But what's disturbing is there's now evidence that the situation is beginning to slide backwards.
Yes, the government says prosecution remains the most powerful sanction it has to tackle the criminal trade, but it revealed some interesting figures in answer to a parliamentary question just before Easter. They show that over the last year for which figures are available, that's 2010 to 2011, the number of convictions of organised smugglers was significantly down when compared to the previous 2 years.
OK, significantly down. What sort of figures are we talking about?
Well, it's almost halved. So in 2010, 233 people were convicted convicted for tobacco smuggling, but last year that dropped to 133 people, and confiscation orders, that's where the courts order criminals to hand over the proceeds of their crime, they were down from £9 million to £4.7 million. Now, over the past 5 years, seizures of smuggled cigarettes and tobacco have remained fairly constant, but the fact that over the last year the number of convictions has dropped sharply suggests problems in convicting tobacco fraudsters.
Indeed they do. Let's bring in Debbie Corris. Her family has been running a tobacconist in Kent for the last 41 years. Hi, Debbie.
Hi.
So do you get approached by criminals offering to supply you with smuggled tobacco?
I have had, I had two men walk into the shop, put well-known hand-rolling tobacco on the counter and ask if I wanted to buy it.
And how cheap are they compared to buying them legit?
Well, it's less than half price normally.
Really?
Obviously, I didn't actually ask them how much they wanted. I just politely refused. But it's generally on cigarettes, I think, at least half the price that I would sell them for.
So that must be very tempting for you, even as a legitimate trader. I mean, you're obviously not somebody who wants to deal with these smugglers. Did you tip off the police?
Yes, I did, yeah.
And what happened?
I spoke to the police the day it actually happened, and the next day these guys came back and was sat outside a cafe trying to sell it to passers-by. So I phoned again, and the police did actually speak to them and warned them about what they were doing. They claimed they didn't know they were doing anything wrong.
I mean, your customers, presumably, are on the street, in the case that you've identified there, being offered the chance to buy cigarettes much cheaper than you can sell them legitimately. It must affect your trade.
Well, yes, I'm sure it does. I mean, it's very difficult to quantify by how much, because we've had such a big smuggling problem for such a long time now. I wouldn't know what my sales would be if we didn't have the problem. Obviously, if there's a boot market or something like that in the area, I generally have a very quiet day.
Really? They're being sold openly at boot markets, car boot sales?
They're being sold openly everywhere now. That's the trouble. It's become almost the norm to be able to go and buy them anywhere.
And do customers now expect you to be selling cigarettes cheaper than the official price?
Yep, I've had that as well. I was a customer came in and said, "Oh, have you got any cheap cigarettes?" So I said, "What do you mean? Sorry, there's the prices," and showed him the prices. He said, "No, the cheap ones." So I said, "No, I think you've got the wrong shop." I've had other customers come in and say, "Have you got any cheap whites?" Again, at the time, I hadn't actually heard about them, but that's becoming a big problem now as well.
And what's that?
It's a packet that's actually made to look similar to our sort of cigarettes. I think there's one that's called Camel, but it's got a goat on the front or something. So again, about half the price of...
Clearly a serious problem, and a serious problem for you in your trade. Debbie, thank you for that. The people responsible for detecting illicit tobacco and cigarettes in shops are, of course, trading standards officers. Let's speak to Dave Hoff. He's the Principal Trading Standards Officer with Herefordshire Council. Good evening, Dave.
Good evening.
So, rural Herefordshire then. How widespread a problem is this?
We've seized over 360,000 cigarettes in the past 15 months. And a number of packets of this hand-rolling tobacco from various sort of the continental worldwide stores mainly that we have the issue with.
Yeah, and I mean, Debbie talked about customers expecting shops to sell the imported illegal cigarettes at a discount. Have you got evidence that shops are selling them in that way in Herefordshire?
These shops are selling the cigarettes at a considerably less price than what you would get a normal, genuine packet of cigarettes.
But if they're doing it so openly, can't you simply prosecute them and drive them out of business?
The legislation we have is that we look for whether they've got a pictorial representation of the health warning on them, and we have to get a purchase of them first.
Yeah.
Before we can take any action, then we can seize the products. Then our main issue is trying to find who is the actual owner of the cigarettes.
Right, but it's not simply the fact that the shop is stocking them and selling them illegally. Is that not enough for a kind of a stiff fine and maybe even a jail sentence?
Yeah, what's happening is when we've gone back in now, where we started seizing high amounts, the number of cigarettes they're keeping on the the shelves, or actually under the counter they are, so they're not actually on display.
Yeah.
They're reducing, so they only keep a small amount in the shop, and the person who supplies it, so it could be just the shop assistant, is the person who's committing the offence.
Oh, really? So you're dealing with the small fry in this business. I mean, what greater powers would you need to go after these offenders more seriously than you are at the moment? Because convictions are down.
Yeah, that's right. We have convicted and taken prosecutions against sort of people who are selling this. But if we could have something like on-the-spot fines or even closure powers of actually being able to close the shop down for a certain period of time, which would hit them in the pocket even harder.
Why do you think that the number of convictions is down, though? Because it is a significant reduction, and there's evidence clearly that it's still a massive illegal business in tobacco.
Yeah, I think sort of from our point of view, it's very difficult. We're trying to find out who the owners are of the premises, who the owners are of the cigarettes even. It is very organised. It's an organised crime, and it's just very difficult to find who is the actual sort of people behind the actual the organisation of it.
Dave Hoff, thank you very much indeed. And Rob Cave alongside me. I mean, cigarettes and tobacco, always a favourite for the Chancellor when it comes to the budget. Is there any evidence that increasing the duty on cigarettes does create a bigger market for criminals? Because that's what some people say, isn't it?
Well, the tobacco manufacturers certainly think that, and as you said in the budget, duty in a packet of 20 cigarettes went up by 37 pence, and a similar amount on a 25-gram pack of hand-rolling tobacco. Now, the Treasury acknowledged that this hike in duty could encourage some people to buy from the bootleg market, but they also say that higher duties also encourage people to give up smoking.
Let's speak to Will O'Reilly as a former Detective Chief Inspector at Scotland Yard. He was commissioned by the tobacco manufacturer Philip Morris to investigate the illicit tobacco trade in the UK. Hello, Will.
Hi, good evening, Adrian.
Yeah, so how significant do you think the problem is?
Well, it's been described to me by some people in law enforcement and in some towns as chronic. I mean, I would say the illicit trade is rife more or less across the UK. I did a research around a number of the cities which intelligence suggested that the illicit trade was quite high, and found it very easy to buy illicit cigarettes from a variety of sources, really, from corner shops, from unscrupulous retailers, from car boot fairs, from people in the street, from a fag house, for instance, and we even found organised delivery around.
A fag house? What's that?
Yeah, a fag house. It's like an inner city estate, a house in there that's known as a house of dealing in illicit cigarettes, much as the same as houses deal in hard drugs. On one occasion, we were approached by a young girl with babies in the street, asked our test person to look after her babies while she went in and got supplies from us from a fag house in the middle of an estate. We've even been offered single cigarettes, clearly aimed at young children, from a retailer. I mean,
if you can find all of this evidence, Will, sorry to interrupt you, if you can find all of this evidence so readily, you've obviously made it your business to go out and research this. Why do you think it is that convictions are down? Because on your evidence, there's no sign that the problem's going away.
No, there isn't. Certainly the problem's not going away, and we've had an empty pack survey this last year suggesting that the problem is higher this year after 5 years of decline.
An empty pack survey? What's that?
Yeah, but basically it's something that's been running now for the last sort of 5 or 6 years, where it's a random collection from streets and easy access bins across the UK. This year, for instance, 105 cities and towns, all with populations over 100,000 people.
So you root through the bins and see where the cigarette packets have come from?
Yeah, a market research company does that on behalf of the tobacco manufacturers and looks at the trends. And after years of decline, this year has shown a significant rise, which is attributable really to a variety of factors: the economy, the recession, the availability, and I guess the cost comparison. Some of these cigarettes you can buy for, £1.50 in another European country, and as you said with the start of this article, it's over £7 in the UK now.
So do you think that the increase in duty on cigarettes is driving smokers into the arms of the illicit trade?
Absolutely. I think the evidence is fairly substantial for that. And of course, the problem is if we've got to be careful that we do nothing to make the situation even worse.
Will O'Reilly, really appreciate your time tonight. Thank you. Rob, what do HM Revenue and Customs say about this?
Well, they turned down our invitation to be interviewed on 5 Live Investigates, but they have sent us a statement saying that the government has provided more than £25 million in extra money over the next 4 years to support the strategy against tobacco smuggling, but they were unable to help us with our central point as to why the conviction rate for illegal importers has gone down.
Rob, thank you. I wonder if you've got any ideas on why the conviction rate then for illegally imported tobacco has gone down, and why is there such a boom in illegal cigarettes in this country? You can drop us a text to 85058. You can email goldberg@bbc.co.uk, or on Twitter, we're at BBC5Live. Now, last month on 5 Live Investigates, we warned that immigration queues at Heathrow Airport could reach crisis point during the summer as record number of visitors arrive for the London Olympics. A few days ago, MPs waded into the row, raising their concerns, and now we've discovered that the Home Office is spending £2.5 million employing extra staff to deal with the problem. The cash includes rehiring former border agency workers who had previously taken redundancy or early retirement. Some will have to be put up at taxpayers' expense in hotels because they now live away from London. Let's speak to Stephen Taylor. He's branch secretary of the Public and Commercial Services Union for immigration staff at Heathrow. Good evening, Stephen.
Good evening.
Yeah, so just remind us what exactly is going on.
Well, if I can sort of give you a background, morale at the moment at Heathrow is probably the lowest it's ever been. Some 18 months ago, as part of job cuts across the civil service, more than 100 staff were allowed to go on early release and early retirement at Heathrow Airport, and that's probably over 400 nationwide. This is frontline immigration staff. And as a result of that, essentially we're now in a situation where staffing levels at Heathrow are so bad that in a moderately busy period, like the Easter period that we've just had, over 30 members of staff from other areas of the country were brought in just for the Easter period. We're not talking about the Olympics here, we're just talking about a normal holiday period, which isn't even the busiest period of the year.
So when the Olympics comes, we're getting people who have taken redundancy, who have retired from the border agency, are now having to be rehired, having previously been surplus to requirements.
It's farcical that there's such a false economy. Essentially, we imagine that several hundred, if not millions of pounds was spent allowing people to go as part of the comprehensive spending review. And now these same people are coming back and being retrained. You're talking about providing something in the region of 585 people every week for the front line during the Olympics in order to try and cover for the gaps that have been created by losing the jobs in the first place.
And some of these will be border agency staff brought from other departments, I understand. Others will be civil servants sort of drafted in. Do you know the total cost of this exercise, of covering the extra demand during the Olympics?
Well, the figure that we've been given for the budget for housing and staffing and travel and subsistence and accommodation is £2.5 million. And we've been told, and this is obviously, some of this may not have been necessarily been corroborated, that there are people being brought in who've retired abroad in order to stay in hotels during the Olympic period and cover the front line.
That's amazing stuff. I mean, how much of the cash is being spent on putting people up in hotels?
We haven't been given that figure, but from the indications are a large proportion. We're certainly aware that the staff coming back from retirement are earning something in the region of £20 an hour. And
is that more than regular staff would get?
A great deal more. And other staff from other areas of the Home Office who've never stamped passports ever, and other staff from other government departments and other areas of the border agency are being brought in as well, and they're all getting additional funds on top of their salaries as inducement to help out on the front line.
How much?
It varies depending on grade and location, but as much as £1,100 on top of their normal salary for staff currently employed by the Home Office.
Sounds absolutely shocking. I think listeners will be amazed to hear what you've told us tonight. Stephen Taylor for the PCS Union, thank you. Last week it emerged that MPs also have their concerns, among them Jerry Sutcliffe, who sits on the Culture, Media and Sport Select Committee, and he attended a meeting with BAA, which runs Heathrow, and the UK Border Agency. Good evening to you, Jerry.
Good evening.
Firstly, what's your reaction to what you've just heard from the PCS Union?
Well, unbelievable, really, isn't it? You know, that you can allow people to leave when you know, and we've been planning for the Olympics and the Paralympics since we won them in 2005, you know, so not to plan ahead and let people go is outrageous. And then the cost of bringing people back, I mean, that's something we will have to look into further.
Yeah, I mean, you talk about the fact that we knew the Olympics were coming. I mean, from your meeting with BAA and the UK Border Agency, did you get the impression that enough planning had gone into the Olympics?
Well, this was a briefing of BAA, the Olympic Board, and Heathrow, and you got the impression that they were clearly, focusing on the Olympians and all the paraphernalia around the Olympics, which was fine. But when asked the question, well, what about other visitors? Because we want people to come to the UK. You got the distinct feeling that they hadn't thought about that, and it was a case of, well, we'll have to deal with that with the peaks and troughs that we normally deal with.
Are you reassured following this meeting that the right kind of measures are now being put in place?
Well, this was in February, and they said that they would be, although the Border Agency representative said that they didn't have the resources, and now we've said what Stephen had to say. So clearly we need to pursue this further. We went back to the Select Committee, wrote to Jeremy Hunt, the Culture Secretary, because we were shocked to find that these things weren't in place. So we'll have to now find out if they have done that. And
and finally, Jerry, sorry to interrupt you, because it's really important, isn't it, that this is sorted out, because people are going to be arriving in London for the Games. We want to give them a hearty welcome, not have their first impression of Britain being held in a huge immigration queue.
Well, exactly, and that's the whole point of this, that this is to be a showcase event for the country, and if the first time that people have experience of the country is waiting in the queue for an hour and a half, 2.5 hours, that's not acceptable.
Jerry Sutcliffe, appreciate your time tonight. Thank you very much indeed. I should stress that we did invite the UK Border Agency to take part in tonight's programme. They issued a statement saying that we are well prepared for the Olympics with additional staff available for busy periods, but we will not compromise on border security, and we are working with BAA to ensure that we are ready to deal with extra passengers. The agency refused to respond to questions about the financing of the contingency arrangements. Thanks for listening to the 5 Live Investigates podcast. And don't forget, if there's something you want us to investigate, our inbox is open 24/7. Just email goldberg@bbc.co.uk. That's goldberg@bbc.co.uk.
On digital and online.
This is BBC Radio 5 Live.
bbc.co.uk/5live.